164, People versus Harris.
Good afternoon. 2 minutes for rebuttal, please.
2 minutes. Go ahead. You're on.
My name is Alexis Asher, and I'm here on behalf of Davon Harris. The record in this case is clear. Juror O did not understand and had a hard time accepting that a witness may intentionally lie under oath. We know this because twice defense counsel asked this juror, "Do you think somebody would not be telling the truth even if they were under oath?" And twice this juror said, "Well, if they're not telling the truth at that moment, it might be because maybe they forgot something."
I'm surprised you even got to ask those questions, because there are places where the judge would say, "Move on." That's not, that's not the purpose of jury selection. And it just seemed a little confusing to me the way the thing was being approached. I mean, I don't know if the witness can even understand what you're talking about when you ask questions like that.
Well, first, Your Honor, I respectfully disagree with you that this wasn't appropriate for jury selection. I wouldn't want this juror sitting on my case if my case rested on the credibility of the people's witnesses.
Well, hadn't counsel gone through a whole thing about, sometimes people's perception and they make mistakes and all that? I mean, doesn't that have to be factored into how this prospective juror was answering the questions?
Of course, and the series of questions that encompass the two outstanding questions and the answers make the juror's answers even more harmful. Counsel establishes that this witness believes that a person could lie, that cops could lie, and that somebody might not want to admit that they lied. And then when counsel...
Is that new to anyone? I mean, if you were asked that question, do you think people can lie? You would say, gee, I'm not sure. Or if they're under oath, do you think they can lie? Gee, I'm not sure.
But when counsel asked if that person's under oath, do you think that person would be telling the truth? What the juror said was, well, at that moment, I would think that they were forgotten or mistaken. And that's a big deal.
Nice thing to say. In fact, did you ever have a police officer say, that's not a Catholic Bible, so when I get sworn, I'm not really sworn?
But you also want a juror to acknowledge that sometimes people can take the stand and they can take that oath, but they're still lying.
Okay, but the court says sometimes people can lie knowing they're lying, and the juror says, right. Why doesn't that resolve this?
People, not witnesses, and not under oath.
Well, most witnesses are people. I found that out in my own private practice.
But the oath here, in this colloquy, meant something more for this juror, and that's what counsel was trying to get at. And in fact, when counsel brings this to the court's attention during the challenge part, the court says, well, that question wasn't asked of this witness. So the court acknowledged that the question that Judge Rivera points out didn't pertain to a witness who was under oath. It just pertained to people lying in general, which had already been established.
Well, counsel, but didn't the question after that, after one of those attempts to get the witness to, or the prospective juror to say that you either have to believe that somebody can lie under oath or not, wasn't there an attempt, I mean, it looks to me like there was an attempt to rehabilitate that witness by the defense counsel when defense counsel said, but that's what you believe, and then you look at what they say, correct? And the juror said, yes, I look at what they say. So if that suggests that the witness would be able to determine whether, or at least consider whether someone was telling the truth or not under oath, because that's the line of questioning about under oath.
Right, but not when it's read in context with the two questions that were asked earlier. If a witness is under oath, after this juror already acknowledged that they believe a person would lie, when it comes right down to the oath, do you think that they would be telling the truth if they were under oath? That juror still said, but only if they were mistaken. So the question that you point out doesn't really clear up the two answers that the juror had given. And the two answers the juror had given, that was really bad stuff. I mean, all you need under the statute is it likely that this juror's state of mind would preclude it from, being impartial and evaluating the evidence.
What in your mind should the normal juror respond to these questions?
As a defense attorney, I would want that juror to affirmatively state, yeah, I acknowledge that somebody can take the oath and, and still lie. That's exactly what you want.
That's surprising. I'm just wondering. Never mind.
I believe plenty of people probably, like this juror, believe that the oath means something. That, you know, if you're not telling the truth while you're under it, you're mistaken. But the point is that you need a juror, especially in this case, when the case rises and falls on the credibility of the people's witnesses. You need a juror who's going to be, you know, on board with you. Not already go and sit down in the panel and already think, well, you know, the people's witnesses are telling the truth. That's one strike against you, and that's why it mattered. And just one other thing on this issue is that...
Is the fact of lying that matters, or the fact that it may not be an accurate response? And isn't the point whether or not the witness can discern whether or not a response is correct? Because he says, or he responds, do you believe that a police officer can lie? Yes. Sometimes people can lie knowing they're lying. Right. And then he says, yes, I listen to what they say. I think about what they say. And isn't the point, he's already said, yes, I believe an officer and anyone else might actually lie. And then I listen to what they say on the stand. So isn't the concern about understanding the accuracy of the response and discerning from that if there's some reason this lie has meaning in the context of the trial?
Of course, but just because the juror says, you know, I could listen and I'll make my own assessment, doesn't mean that that juror is going to factor in the possibility that this person is intentionally lying. And that's the problem with this case. You already start off, like I said, with one strike against you. If you have a juror who's seated and who already gives more credibility to the people's case.
Are you saying that this particular inquiry, with this colloquy with this juror, suggests that this juror is completely closed off to the possibility that people will lie on the stand? Or, as you say, the court's assessment of this is, well, you never really asked that question.
I'm saying both. I'm saying that this juror never acknowledged that possibility, and that's why it's a big deal. But then I'm also saying, and you're bringing me to the point that I wanted to make, was that the judge was wrong. The judge said, well, the juror was never asked this question. But the judge is wrong. The record shows that the juror was asked this question, and the juror still couldn't state affirmatively that they recognized this possibility.
What other issue you want to deal with? Your time is short.
Yes. The Turner issue. I present to you the rare and exceptional case where a defense counsel's failure to raise a winning statute of limitations defense constitutes ineffective assistance to counsel.
Just like Turner?
It's exactly like Turner. There was a winning...
There was no strategic reason for keeping the petit larceny charge in?
Absolutely not. And
Even if there would be testimony, as there was, that something was stolen from the premises after your client came into it?
That testimony would have come in with or without the petty larceny count dangling there. We know that this wasn't a good strategy because defense counsel used his basis for the burglary was no larceny happened. So why would you want to have the object of the burglary sitting there for the jurors to consider?
If the jury believed that something was actually stolen from the property, then you would have this dilemma of whether the jurors would then convict him of the felony as opposed to the misdemeanor petty larceny, right?
No, not so. The jury still could have convicted him on the petty larceny and acquitted him on the burglary, found that they didn't prove the intent that when he went in there it was to steal, but found that the theft was completed nonetheless. That's why his strategy didn't work. That's why there was no strategy. That's the biggest...
Let me ask this. Turner says that the error has to be dispositive to apply. Are you saying that, let's assume it's an error, he should have made a motion to dismiss the petty larceny charge at the close of proof on the statute of limitations and then say, because I can't prove the petty larceny, I move to dismiss the burglary. The burglary probably still would have survived, but nonetheless he should have made that motion. So you've got a partial Turner problem. It's not, you can win on the statute of limitation charge, but it's not dispositive. Since it's not dispositive, then we're into, was it ineffective assistance of counsel, and is there a strategic reason?
But it is dispositive on the...
No, it's not dispositive of everything, because the one charge survives. So it can't be dispositive. So, and I don't think we've dealt with this problem, at least in my research, I wasn't able to find it, and it's, I think that's the edge of this particular spear here. Is a partial Turner possible where there isn't a purely dispositive action that the court can take by a clear error?
It was dispositive to the misdemeanor that he didn't need
Yeah,
for
but
the
that's not what
burglary
Turner
charge.
says. That's not what Turner says. You got to be able to throw out the whole case. Otherwise, we're talking ineffective assistance of counsel purely, and is there a strategic reason?
Along those same lines, on page 5 of your brief, you do say that the petty larceny conviction must be reversed and that count dismissed. Is that the relief you're requesting?
Yes.
You're not requesting that the burglary be reversed?
No, the relief is at the petty larceny, which the winning statute of limitations issue applied to would be
Okay,
dismissed.
counsel.
Thank
You'll
you.
have your rebuttal. Let's hear from your adversary. Counsel, we'll start with the petty larceny. Why shouldn't we throw that out?
Yes, Your Honor, and good afternoon, Your Honors. My name is Christine DeSalvo on behalf of the respondent, Richard A. Brown. Your Honors, there was a legitimate strategic reason for defense counsel to
What was
maintain...
the legitimate strategic
The
reason?
legitimate strategic reason was this was a very unorthodox case with very bad facts for the defense. The defense attorney here wanted to focus the jury on the petty larceny evidence, which had apparent weaknesses.
Why?
And he wanted to not have the jury consider the petty larceny as an afterthought. He wanted them
As
to
a
fully,
what?
As an afterthought. He wanted them to fully deliberate on the petty larceny charge because of the facts of the case, the fact that the defendant unlawfully entered this apartment.
You could have the burglary without the larceny, right?
Well, here, Your Honor, the specific charge to the jury that the court gave was that in order to find the defendant guilty of the burglary count, they had to find that the defendant unlawfully entered the apartment with the intent to commit the specific crime here of the petty larceny. Because of how rare this case was, in the sense that the other facts that were present, the other evidence that was elicited at trial, was that the defendant also, while he was in the apartment, masturbated and then ejaculated on the victim.
Yeah, but he could have been found guilty of the burglary without being guilty of the petty larceny, right? I mean, he could have intended to commit petty larceny and then not succeeded.
Well, Your Honor, usually in a particular case, the intent and the completed crime are not one and the same. However, here, the evidence of the defendant's intent to commit the crime and the completed crime were one and the same.
He's not trying to create a repugnancy situation here, right?
No, Your Honor. But here, well, if the petty larceny would have been dismissed and it would not have been on the verdict sheet, and had they convicted of the burglary, then he would have had no way of knowing in that situation whether they actually convicted because of the petty larceny or they convicted him of the burglary because they considered.
Isn't the real reason because the victim couldn't identify any stolen property, and she didn't even mention to the detective who testified that there was no stolen property. So if I'm the defense attorney, I want to say, look at this. You know, she didn't even report any stolen property. Now we're in here on a larceny charge and nothing was taken.
Yes, Your Honor, but that supports my argument in the sense that he relied on those weaknesses
I understand that.
in that evidence.
I understand. That's why I was telling you.
Yes,
Okay.
and he relied on that in his summation. And in fact, it was implicit in his summation that this was his strategy, to focus the jury on the petty larceny
So he
evidence.
was trying to create a compromise for the jury, you're saying, because if the petty larceny charge was gone, then he could only be convicted of burglary?
Well, his argument on summation was that if the petty larceny fails, the burglary fails as well. Yes, so he would have an acquittal of the petty larceny.
Compromise the burglary verdict with the petty larceny? You could still have it. I don't know why you say that.
Yes, you can still have it, Your Honor, but there's a difference with having a charge on a verdict sheet, having it before the jury, having the jury go down the verdict sheet, deliberate fully on a charge. If it had not been there, it's very possible that the jury would have considered the masturbation.
Yeah, but the evidence of the theft could be admitted as part of the burglary, right?
Yes, the evidence of the petty larceny would have been admitted had it been on the
Right,
verdict
so
sheet.
why don't we just throw out the petty larceny? Why isn't it clearly a Turner type situation?
Well, it's very distinguishable from Turner because in Turner, the defense attorney placed on the record that he did not want the time-barred count to be considered by the jury, completely disavowed any sort of strategy he may have had to have the time-barred count be considered. Here, that's not the case. So for that reason alone, it's completely distinguishable from Turner. And also, to dismiss it here, the harm is that this Court would be finding an error where there is none. It would be finding that defense counsel did not have a legitimate trial strategy for keeping it on the verdict sheet where he did. In a case that the facts were very bad for the defense, he wanted to focus the jury on the pettit larceny charge, the evidence of which he perceived as very weak, and to get them away from the masturbation, which, by the way, was very counterintuitive.
Didn't he also successfully have the court instruct the jury that masturbation was not a crime at the time that this alleged burglary was committed?
Yes, Your Honor.
So why would he need to keep the pettit larceny focus? Why would he need to have the jury focus on that when the court had instructed the jury that masturbation was not a crime that they could consider as the underlying charge for the burglary?
Well, Your Honor, I believe it's more effective, again, to have it on the verdict sheet, to have the jury see the charge, to have them know that they need to fully deliberate on that evidence, rather than to just hear it from the judge during the charging, where the judge would go on and explain to the jury that masturbation was not a crime at the time, which is counterintuitive to people and arguably extremely more heinous than to anybody to have their property stolen. So he wanted to focus the jury. He wanted to focus the jury on that evidence. He relied on the weaknesses in that evidence in order.
Let me ask you this. Isn't it just a better policy to say you can't charge people after the statute of limitations is done, no matter what the situation is? We don't want people charged if the time to bring that charge is expired. And then whenever anybody's strategy is, that's their strategy. But as a policy from this court, it's 2-year statute of limitation on misdemeanors. You can't charge them on misdemeanors 10 years afterwards. That's just should be our policy. Why isn't that a logical approach for us to take? And then whatever strategies counsel takes, well, then that's the strategy counsel takes. But how does it make sense that we're allowing someone to be charged with something that they cannot be convicted of?
Well, Your Honor, it's not a logical approach because, one, under the rules of professional conduct that guide the prosecutors, prosecutors are permitted to charge crimes so long as there is probable cause, a cause that supports those crimes. There is no limitation that our office cannot charge crimes that are time barred, and in essence, they are very.
But don't you agree with the judge, though, that it would be better not to? Why would you charge someone when the time is run?
Well, Your Honor, it's beneficial to the plea bargaining process.
So you can charge people with things that you cannot be convicted of to enhance your plea bargaining position? That doesn't seem like a public policy that any of us would really advocate.
Well, it's not just that. It's also beneficial to defendants, many of which who choose to waive this defense.
I've never met a defendant who thinks it's better to get charged with more crimes, particularly ones they can't be convicted of.
Well, here, Your Honor,
isn't that your better argument that it's an affirmative defense? I mean, you don't have to worry about the statute of limitations. If they choose to assert it, they may. If they choose not to, they don't have to.
Yes, correct. And here, didn't assert it.
Which is why.
Which is what we're looking at.
Relied on it, wanted it on the verdict sheet, and to have a rule where.
Yeah, but the whole question is that okay for them to do that?
Well, it's okay, and it's completely ethical to do it.
Yeah, but it doesn't help their client, that's for sure.
Well, it doesn't help their client.
It's not effective representation, is it?
Well, no, it is, Your Honor.
It is?
It's effective representation to have time-barred counts on the verdict sheet depending on the circumstances of each case. For example, in this case where the facts were bad and he faced an A misdemeanor, it was a pettit larceny A misdemeanor, the evidence of which would have come in had the pettit larceny not even been on the verdict sheet.
So it summarizes, what you're saying is that the jurors that your opponent didn't like picking, but they could have said at some point, we convicted him of petty larceny, that's enough. You know, we like him, he's a nice guy, the defense lawyer did a good job, why don't we just convict him of petty larceny and go home? Because we can't agree on something else. But if it's not there, they only have one thing to convict him of, and that's going to be the felony.
Yes.
So then he's convicted. You bring a 440 motion and you say it was ineffective assistance of counsel to not to strike that out because that's the only thing that's left. And, of course, then that charge would be thrown out on it because under Turner then it would be dispositive and it would be out. So that's why you shouldn't bring things that are blown on the statute of limitation already, because you create that error where you wouldn't have otherwise.
But then to hold otherwise would be to put future attorneys who are in a position where it is a very unconventional case with unconventional facts that calls for an unconventional strategy, they would be in a position at that point where they would have to move to dismiss the time-barred count, constitutionally required to do so when they didn't deem it necessary or they actually wanted it on the verdict sheet because of the particular.
What makes it so unconventional? Maybe
Well,
I missed
just the-
something here in your argument. What's so unconventional?
Well, the facts of the case alone are just, I believe, are somewhat rare in the sense that the defendant enters this apartment illegally. He steals this woman's property, and then before he leaves, he masturbates, and then he ejaculates on her. I think.
So no one ever does anything like this where they enter with the intent to commit one crime and become very opportunistic in the moment?
Yes.
And commit another?
Yes. Yes.
Well,
but-
then why is this rare?
Because it was not a crime at that time. In 2002, when the crime was committed, it was not a crime under the penal law. So that's what makes it rare, because now a defendant is at trial. He's faced with these bad facts for his client that the jury is going to hear, and he wants to steer them away from these bad facts so that they can focus on
Would
the
this be a different case, counsel, if the masturbation weren't in the scenario at all? Would it be different? Would you be arguing differently that he still would have some strategy, a strategic reason for keeping the petit larceny in?
No, Your Honor, because here the petit larceny and the burglary were inextricably intertwined.
So it wouldn't be a different case if the masturbation weren't involved?
No, Your Honor.
Okay, counsel.
Thank you.
Rebuttal, Kat.
Just briefly, Your Honors. Counsel could have done exactly what he did without the charge being on the verdict sheet. He could have made the same arguments in summation. He could have guided the jury towards finding that this was a burglary, but the intent was the sexual offense, without ever having the petty larceny there, risking an additional conviction. That's what the misdemeanor was, an additional conviction that he did not need.
Is it not rare? Our argument about it's a whole rare situation?
The facts of this case were unique, and as I said, this is the rare case, 10 years after Turner came down. Here's the rare case where defense counsel's ineffective again, and this time it happens to be on a misdemeanor. There was no reason in the world to have that misdemeanor on the verdict sheet, and in fact, it compromised his strategy on the burglary.
I would have thought, I can see it, where you think if you can get an acquittal out of the petty larceny, you can get an acquittal on the burglary. I mean, the jury could say, well, couldn't find the jewelry, we don't believe that was a petty larceny, therefore there's no burglary.
But for the burglary, you just need the intent. And the facts of this case was that the woman went to sleep. She left the windows blinds open. It was 3:30 in the morning.
Right, but I guess the argument is that if you want to say the guy's a pervert and he came in to do perverted stuff and that's a burglary and that's all they got, they may not like the man because of his sexual conduct.
But then you run the risk that the jury could also convict you of the petty larceny and then convict you of the burglary, and then you're convicted, as Mr. Harris is, of a time-barred charge.
It's a strategy. I mean, maybe it worked, maybe it didn't.
Yeah, but
it's a strategy.
It's an unreasonable strategy.
That strategy would entail arguing on the one hand that there's no proof of the larceny, and on the other hand, hoping that they're going to find that he committed the larceny but not the burglary, right?
It's a big risk to take because you risk your client ending up as Mr. Harris did, convicted of a time-barred charge.
Okay.
Thank you.
Thank you both. Appreciate it.